Federal law gives the Securities and Exchange Commission broad power to regulate communications regarding transactions involving publicly traded companies. The intersection of that power and the First Amendment arose in Long Island Lighting Company versus Barbash. The Long Island Lighting Company, known as LILCO, was a publicly traded electric company serving 2 Long Island counties. LILCO's shares were registered pursuant to the Securities Exchange Act. John Matthews ran for Nassau County Executive in the November 1995 election. Matthews opposed LILCO's operation of a nuclear power plant. He advocated replacing LILCO with a publicly owned electric utility. Matthews bought 100 shares of the company's stock and managed 100 more owned by his company. Matthews initiated a proxy contest seeking to elect a majority of LILCO's board at its shareholder meeting in December. The Citizens Committee to replace LILCO, which we'll call the committee, sought to replace LILCO with a publicly owned utility company. The committee also opposed LILCO's construction and operation of the nuclear plant. Matthews and the committee ran newspaper and radio advertisements criticizing LILCO's management and advocating for its replacement with a public utility. About 2 weeks before the election, LILCO filed a federal court complaint alleging that Matthews and the committee published materially false and misleading advertisements in conjunction with a proxy solicitation, in violation of the 1934 Securities Exchange Act. LILCO submitted discovery requests and deposition demands and sought an injunction requiring Matthews and the committee to correct the allegedly false and misleading statements and file their so-called proxy solicitations with the Securities and Exchange Commission. Matthews and the committee responded with motions to dismiss LILCO's complaint. The district court adjourned all proceedings until the day after the election. The adjournment order directed Matthews and the committee to bring the requested documents to the hearing and directed that Matthews and other deposition targets be available on that date. The court further limited LILCO's discovery. 2 days later, the district court ruled that proxy rules don't apply to general publications and granted the defendants' dismissal motions. LILCO appealed to the Second Circuit.